So thank you, Ilya, for this very interesting and stimulating paper, and to the organizers for bringing us together. Some of the papers are about theory, and some of the papers delve into particular questions and look at the evidence and give us examples of originalist logic. This is the second kind of paper. I actually prefer those. But what I like to do is take the concrete papers, like Ilya's or like David Upham's yesterday, and look at the way in which the problems of theory emerge from the specific discussions in them. And so that's really what I'm going to do, rather than argue whether the conclusions in the paper are right or wrong. What I'd like to do is point out some of the interesting methodological choices that the Soman paper goes through, and reflect upon those in a somewhat more general way. So much of the ground of this chapter of Ilya's book is familiar. A lot of it you see in Justice Thomas's dissenting opinion in the Kelo case, and a good bit of it is familiar territory. But Ilya makes a claim for a novel contribution, specifically that this is the first study to cover all of the state court decisions that address the question of public use during the time frame surrounding 1868. And so that's what Ilya tells us in the paper is the unique contribution. So that's what I'm going to focus on. I think that warrants some attention. And in looking at getting into the weeds of his analysis here, I think that it will indirectly address at least two rather interesting theoretical questions. One is what is the logical significance of 19th century cases for understanding either the 14th Amendment or the Bill of Rights. Second interesting question is, how do we deal with mixed evidence? And then there might even be a little bit in here that we can touch on about what is the theoretical relationship between originalist analysis of the 14th Amendment's incorporation of the Bill of Rights and the original Bill of Rights. So the guts of the Soman paper are two sets of data. The first is presented to us conveniently in Table 2.1 of his paper, and this, he tells us, is all state court decisions touching on the question of public use as of 1877 that interpreted state constitutional public use provisions. And he finds 25 states in which there is a decision on this subject, and they split. He tells us 16 of these states adopt what he describes as the narrow interpretation, which is to say that public use is only, or that property can be taken only when it's actually going into governmental ownership or into private hands where there is a legal obligation of access to the public. And 9 of those 25 adopt what he calls the broad interpretation, which would mean that that the use by a private party satisfies the public use requirement so long as it serves some legitimate public purpose. He identifies 2 other states in which there are opinions discussing the question, but where he says that it's equivocal and he can't really tell which of the 2 categories they fall into. The second data set is presented not in tabular form, but in narrative form in several paragraphs on pages 17 to 18 of the paper. And these cases he describes as the Mill Act cases, and he finds that he discusses 16 decisions, finds that 4 of them adopt the broad interpretation, that 6 of them adopt the narrow interpretation, and specifically he says that the Mill Acts were held unconstitutional, presumably because their understanding of public use is too broad. And then he identifies 3 cases where the courts uphold the Mill Acts, quote, on the basis of prolonged acquiescence and usage, but without endorsing the broad view of public use more generally. That's his characterization. And then he identifies 3 cases where the courts uphold the Mill Act on the basis, again, quote, a basis of prolonged acquiescence while explicitly endorsing the narrow view. So I have some, and his conclusion then, which is on page 19 of the paper, he says, if we combine the 6 states that concluded that Mill Acts were unconstitutional with the 3 that ruled that they were permissible while simultaneously endorsing the narrow view of public use more generally, it turns out that the 9 Supreme Court courts embracing the narrow view of public use significantly outnumber those that endorse the narrow. So it is the vote is 9-4. So those are the 2 data sets, and those are his conclusions. So I have some questions about this, and then some other comments. But first of all, I don't understand the relationship between the 2 data sets. And Ilya, I suggest maybe that you just, I'm sure you know the relationship. At first, I thought perhaps the Mill Act cases were a subset of the Table 2.1 cases, but when I compare the actual states, it turns out that they are not, that can't be so. So if they're not a subset, what are they? How can there be, how can Table 2.1 have all of the cases interpreting the state provisions, and then a separate set of decisions that are about the Mill Act cases under those state constitutional provisions? I just don't quite see how the 2 fit together. I'm sure there's a perfectly adequate explanation for that. I suggest that you explain that in future drafts. The second comment about this is that I would have liked to have seen some discussion of what those cases in Table 2.1 are about. That is, you know, first of all, it would just help my understanding of the way in which the debate goes on to know what kinds of statutes there were passed in the early 19th century that took land from one private person, gave it to another private person, and you know, what were they? We know the Mill Acts, we know the private road cases from the chapter, but what were the others? And in particular, I wonder whether the nature of the underlying a transaction might explain why courts adopt the broad or the narrow interpretation. So for example, we might have cases kind of like Calder against Bull, where the legislature is transferring ownership in a kind of quasi-judicial capacity, in which they think that, so A has legal title, the legislature thinks it really ought to belong to B, and so we have a transfer that is purely a transfer of ownership without any change of use. And it seems to me that would be very conducive to adopting the narrow construction. But I also wonder if there aren't some cases in which the property is transferred from A to B because B is going to use the property in a different way, and that different way might be helpful to the public interest. So for example, it might be land that's in the way of a natural gas pipeline, or it might be land that's going to be used for making military supplies that are needed for the war effort, or whatever it happens to be. And it would seem to me that that kind of case would be more conducive to the broad interpretation. And I'd just be curious, of these 27 cases discussed in Table 2.1, is there some explanation for why they come out, or are we just counting them? And then I also wonder, well, what about other possible patterns? Yesterday when David Upham was telling us about different cases, he commented on the identity of the judges. You know, are they Republicans, are they Democrats? I'm curious as to these cases. Are some of these Jacksonian Democrats, or some of them Whigs? What would be the pattern? Is there some explanation for what the disagreement is about? And in connection with that, I think some discussion of what the arguments are on both sides of the cases would be helpful to us. So those are just some suggestions about how I think the paper could become richer and more useful. It's the Mill Act, the second set of data, where I am more perplexed and maybe even more concerned. So first of all of these discussions are of whether Mill acts passed by the legislatures are constitutional under state constitutional decisions. I take it that that means a very large number of states passed such laws. I'd like to know how many, and I would also like to know why doesn't the mere passage of Mill acts where the property is being given to another private party without this legal obligation, why doesn't that count as originalist evidence? I mean, yesterday, David Upham again told us lots about legislatures passing laws, and the legislature passing the law was just as important as any other source. And in fact, David said that he thought that it was the person who either is a representative or is like a representative might even be the most important hypothetical person to look at to see what they understand. Well, here we have representatives passing all these laws. I would think they would count. And so I would want to know how many states passed these things and what did they think they were doing and why doesn't that count? But putting that aside for a moment, I'm particularly interested in Ilya's argument that cases that are based on, quote, precedent or broad usage or prolonged acquiescence should be discounted. This, I think, goes to the question of why are we looking at these decisions anyway? He says at page 11 that we look at these as a window on the public, on the understanding of public use in the years leading up to the 14th Amendment. I would think that prolonged acquiescence and precedent and long usage would be very powerful bits of evidence for the widespread understanding of the public use requirement. And so if I see a court that says, I think, we the judges think that public use requirement means X, but long-standing practice and acquiescence and precedent all cuts the other way, and so we're going to decide it the other way. We're going to adopt the broad interpretation. I would think for originalist purposes, the broad, the acquiescence, the prolonged use, and so forth would count more than the opinion of the judge that thinks that it's otherwise. And yet, Ilya adds those cases to the narrow interpretation. In fact, if you add all 6 of those cases to the broad interpretation, because of the fact that they are a window that in that state, the broad view, the acquiescence, the long-standing practice is broad, you get, instead of having a 9-4 vote, you end up with a 10-6 vote in favor of the broad interpretation, which then leads me to ask, what do we do with mixed evidence, right? 10-6, whatever the numbers might be, do we count up and say that if there's a majority on one side, that that's the correct originalist conclusion? I think not. It seems to me that when we have evidence that there's a serious disagreement, a real split, that what that tells us is that there was no shared understanding. And at least the way I think about these things is text and original history count if we have pretty clear evidence of what they are. But if the evidence is that there was a range of opinion and lots of respectable voices on both sides, then originalism doesn't answer it, and we have to turn to something else like subsequent practice and precedent to resolve the question. Thank you. Sorry to go over.